Jonathan Rooker, let's go ahead and bring him in. John, what are you here to scare people about today?
Oh, I'm here to talk a little bit about DUIs in criminal defense.
Okay, is there such a thing? Don't the cops have it down so good that there's no way you can fight a DUI? That's what they tell you.
Well, they put all these billboards up and they think they're scaring people and cutting down on them, but really they keep getting tougher and tougher and moving the line and sometimes even fudging the line on where a DUI really is.
Wait a minute. Are you saying that the cops might not be telling the truth?
I don't blame the cops so much as once a person gets into court and they've been accused of a crime and they have found some form of alcohol or prescription drug or non-prescription drug in their blood, then it feels like they're trying to prove their innocence, and that's not the way the criminal justice system is meant to work. It is the government's burden to prove a person guilty beyond a reasonable doubt.
Innocent until proven guilty.
Exactly. But too many times, like, they came out with a new study, the NHTSA did, National Highway Transportation Safety Administration, about driving under the influence of prescription and non-prescription drugs. And at the end of it, they concluded that approximately 25% more likely to get into an accident if you're smoking marijuana or have used marijuana and then drove.
Wait. Are you comparing the people that are taking pills and the people that are smoking the pot?
They're actually compared each different category of narcotics, of legal and illegal, prescription and non-prescription drugs, and alcohol.
It's hard for me to believe that someone would be more impaired on marijuana than they would be on painkillers.
It varies. It really varies by person, by how long somebody's used them, by their tolerance. But when you take the same data that the government used to come to this conclusion, and you break it down by age, sex, and race, and you look at in particular categories, the data actually leans towards a person being safer, less likely to get into an accident on marijuana than not. Their data, not mine.
Oh, no! Okay, wait. You're saying that it's less likely someone's going to get into a wreck in a vehicle because they're smoking pot? Against a sober person?
I'm saying that the government
study...
Like
they're extra careful? They're driving slower? What is it?
That is a tendency of marijuana drivers to slow down. But the government's data showed that people were less likely, when broken down by age, race, and sex, to get into an accident while having marijuana in their system than not. It's their study, not mine.
That's crazy.
The same government that wants to prosecute people for being under the influence of marijuana while driving. You can get a DUI for marijuana just the same as alcohol.
Have you heard of someone getting a DUI for under the influence of marijuana?
Amazing number of people that have gotten marijuana DUIs.
In Fresno County?
In Fresno County, in Madera County especially, around the state of California.
Okay. How does this work?
The government, well, you get pulled over, and if you were speeding, if you were weaving, if you got into an accident, if something's gone wrong, or if the much ballyhooed license plate illuminator light was burned out, and they say, I smell marijuana. Have you been smoking marijuana? The worst and the most common god-awful answer you can give is, I've got my marijuana card. You have just said, please take me out and check me for marijuana, and I've got some in my blood. You may be able to find out I'm impaired. That's what you've told the officer.
So what you should tell them is no.
No, don't lie. Don't ever lie. Just, I've been told not to answer these type of questions by my attorney, or I choose not to answer these questions.
Well, doesn't that throw up a red flag? Isn't that going to make them upset with you because you're not cooperating?
One's a red flag and one's a giant firework exploding out of the car with the marijuana card. I've got a marijuana card. I've been smoking marijuana. That does not go over well.
Because that's what people do that have those cards?
That's how they report.
That they're invincible to the police because of those cards?
Very often that's the conclusion that they have.
What do the cops think about those cards?
I don't think they have the same feeling according to the reports I've read.
Yeah? What are the types of things they're saying?
Well, many times they'll use the alcohol field sobriety tests that have not been validated for marijuana to find impairment for marijuana. Other officers have been trained, they call them DREs, drug recognition experts, or they're trained to do a drug recognition exam, depending on how they choose to phrase it. Some call themselves experts. And they'll say that I put him through these series of tests and I concluded he's under the influence. One of the most common non-scientifically based things that several DREs believe is that I had him stick his tongue out and he had a green tongue.
A green tongue?
A green tongue. There is not one
Jolly Rancher.
Exactly.
I get him.
Scientific article that says that it turns your tongue green if you smoke marijuana. Not one. Yet they say they see a green tongue. Oh, yeah. The other is a pulsating carotid artery.
A pulsating what?
Carotid artery. I looked at his carotid artery.
Where is that at?
Right here.
Okay.
And it was pulsating. It's really trippy. You can see it. And they swear by it. I think they believe they see it.
They really write that in the police report?
Yes. Yes.
But there isn't really a test that they can do that it would be conclusive that the person was smoking marijuana while driving, is there?
Exactly. There's not, but they bring in experts that say at 2.5 nanograms or more, and it varies by expert, I believe everybody is impaired by marijuana. But there are no hard and fast studies that show that everybody's impaired at any particular level on marijuana. If, I believe it or not, I do not use marijuana, but if I went and smoked marijuana, I'd probably be impaired. I've seen people that smoke marijuana daily, and I don't believe it impairs them at all. It doesn't do a thing.
I see some people that smoke it daily. It makes them better.
That could be the case as well.
No, I mean, like they're jerks before, and then they kind of mellow out, you know?
It's known to have that effect on people. It does that. Another area is there's prescription like antidepressants or anti-anxiety drugs. And
those are bad.
No, not necessarily. They can be bad.
Give me a statistic, John. People who take the anti-anxiety pills getting less wrecks than people that are sober.
Well, you take somebody who lives at a what is considered defined as the normal level of anxiety, whatever that is, and that's like living in the house. You take somebody who's depressed, they're living in the basement. You take somebody who's over-anxietied up, they're living up in the attic somewhere. You need to get everyone in the same level.
In the house.
Exactly, get them in the house portion of it. So if somebody's up here on anxiety, it could be affecting their driving. If you give them anti-anxiety and it brings them back down, they may actually be a safer driver. If you take somebody who's completely depressed and driving around, not looking up and moping, and you bring them up a little bit, they may be a safer driver for taking.
Because they're thinking clearer?
Exactly. You take somebody with extreme pain, you're driving with extreme pain, it's hard to focus. If they take a Vicodin, they may be a safer driver after the Vicodin than if they wouldn't have taken the Vicodin. But we're usually dealing with this after the fact. They've been accused of swerving, weaving, pulled over, admitted they're on a prescription drug. And as soon as they tell the officer they're on something, yeah, I've taken Vicodin today, the officer targets in and looks for impairment by Vicodin, just a human being doing his job. He goes,
what he's been trained in.
What he's trained to. I found these signs that they may be impaired to the probable cause level by Vicodin. Then they take him in and we end up in court and they've got a blood test and they're looking at it saying, oh, and we concluded he's correct, they did take Vicodin. They may be impaired. And now you're fighting a DUI.
But is there any way to measure the amount that's in their system against their body weight and all that stuff?
Oh, most definitely. They can break it down against their body weight. But what's hard to quantify is what their tolerance is. Some people, just like alcohol, take one drink and they're a little loopy. Some people drink all day and you can't tell. The same thing with Vicodin. Someone who's taken it for a long period of time due to having chronic pain over a period of years, it may not impair them at all. Somebody else may be at the same level, doesn't take Vicodin or doesn't have the same tolerance for Vicodin, and they maybe should not get near a car at all. You don't want them driving. But people that have taken it for a long time or have a better tolerance to it, they can drive perfectly fine under having taken the Vicodin to kill their pain.
Is the alcohol DUI? Can you fight one?
Yeah, most definitely.
Can you win one?
Yes, you can win them. They are very winnable.
Do you win them, Johnny?
I do win some. Yes,
yeah?
I do. There are different levels of winning. Some people get charged with enhancements that come with it, other charges that come along with it, and sometimes the plea bargain to a lesser charge is winning. It's a degree of winning. Mm-hmm. Sometimes going to trial is a degree of winning. Sometimes winning at trial. Sometimes you can just flat get them dismissed. Things come back at the right levels and you have the right arguments. The other one is whether or not you were driving under the influence at the time you were operating a motor vehicle.
Meaning that alcohol hadn't done its job yet?
A lot of people get pulled over leaving bars. And we're sitting right here at a 0-0. If I chugged a pint of tequila and I'm drinking the tequila and I walk out that door and you had a monitor in my arm, you would see the blood alcohol level raising. How long? It depends. Nobody knows for sure. There's not one expert in the world can tell you when I'm going to reach peak alcohol or what that alcohol level is going to be if I drink 8 ounces of tequila right now. Not one. They can't say in 42 minutes he will be here. So now they come in and they guess. They guess whether or not you fully absorbed your alcohol. That's all it is an educated guess.
And they're used to people just bowing down and taking it?
A lot of people do. A lot of people
because
plead
it's
out and
embarrassing and it's hard on them.
Some just don't want to go to court.
They just want to get it over with. They want to put it behind them.
I've had people hire me and they've said, all I want to do is you to go in, get me the best deal you can. I don't want to have to go to court. I'm like, that's it? That's it. Okay. I've had other people, I'm like, this is one of the most winnable DUIs I've ever seen. And I was talking, and in the end, that person decided, I don't want to go to trial.
Gave up.
I'm like, why not? I don't want to plead you out. I'm having a fit. Please go to trial on this. This is incredibly winnable. And the end result was, I don't want somebody to see me and realize on the jury panel that I've been cited with this. That was killing me. I mean, that's a win.
Mm-hmm. What other kind of cases you like to do, John?
Domestic violence cases are always interesting because they're very fluid. The facts seem to change.
Wait, because there's two sides to every story? Is that what you're saying?
Well, it's the timeline seems to change perspective on things. A person who claims that they were assaulted or battered by their significant other on night 0 many times comes to court and says, well, I mean, it was after I struck that person with the towel rack that they hit me. And whether it's self-defense, when it actually begins, what is self-defense, reasonable self-defense? You don't have to wait to hit back. If somebody's charging at you with the towel rack, you can actually protect yourself.
Self-defense and retaliation is different, though.
Very different, very different. You do not have the right to retaliate. You have the right to defend yourself up until the point that the other person is no longer the aggressor. A person can legally, if they run up and sock you in the nose, they committed a battery on you. They go, okay, I'm done, I won't touch you again, and start to walk off. You don't get to hit them back.
What?
They deserve it. Man code says yes, but you do not get to hit them back on principle.
No kidding.
It's almost wrong, but it's the way the law reads. I think if you run up and hit somebody in the nose, you deserve to get hit back.
Right.
And it might be a pretty good defense in court. Some people might sympathize for that position.
A jury might go for that one.
But the letter of the law says as soon as they're done with their attack, you have no right to retaliate.
Wow.
That would be a lesson in self-restraint.
The DUIs, the Fresno Police Department's putting a lot of them on the books. People out there that are unfortunate to get one or stupid enough to get one out there, how do they get a hold of you, Johnny?
They give me a call at 559-496-0123.
Awesome. Always good to see you, man.
Good to see you again.
I always have fun talking to you. Hey, we're going to take a quick commercial break. We'll be right back in the buzz. Stick around.